All right, well, let me just start. I am Haider Hamoudi, the Research Dean, the Associate Dean for Research and Faculty for Development, for those who don't know me. I am going to shut up and sit in the back and eat pizza, which is my sole role here. Well, I supplied the pizza, so you're welcome. But I did want to just sort of thank everybody for coming, and also thank both the Christian Legal Society and Outlaw for playing such an important role in helping to bring this out. We've been working very, very hard to try to have more student faculty. I'm moving your PowerPoint. More student, you know what, you can fix it. Hold on. More student faculty. All right. See, I was going to shut up, but I actually ruined the thing first. Okay, so more student-faculty engagement on issues of scholarly concern, and I think this is an excellent example of one that is of interest to both students and to faculty. So thanks to both Dr. J. Michaelson and Professor Ira Carroll for participating. I will turn it over to both Wes and Jason, who represent Christian Legal Society and Outlaw, respectively, to introduce the speakers and to moderate the discussion that follows their presentation. So thank you again, everybody, for coming.
Hi everyone, welcome. My name is Wesley Pritchard. I'm the president of Christian Legal Society. I just want to thank everyone for coming to this discussion on religious liberty, civil rights, and public policy. You'll be hearing from Dr. J. Michaelson and Professor Ira Carroll today. So I'm going to hand it over to Jason from Outlaw, who is going to introduce the speakers.
Good afternoon. Again, my name is Jason. I'm the Vice President of Outlaw, and we're so thrilled that you're all here today. Really excited to introduce both speakers. I've actually known Jay for about 8 years, doing Jewish LGBT student work back in the day. And just to offer a little bit from his bio, he's a legal affairs columnist for the Daily Beast and an affiliated assistant professor at Chicago Theological Seminary. He has been a leading authority on the U.S. religious exemptions movement for 5 years and is the author of the 2013 report, Redefining Religious Liberty. Dr. Michaelson has discussed religious exemptions on CNN, NPR, and MSNBC, and has published on the issue in Reuters, The Washington Post, Religion News Science, and The Forward, and given presentations on the issue at Yale Law School, Brooklyn Law School, University of Arkansas, University of Central Florida, University of Pittsburgh, and other institutions. Michaelson holds a JD from Yale Law School, a PhD in Jewish thought from Hebrew University of Jerusalem, and a non-denominational rabbinic ordination. He has held teaching positions at Boston University Law School, Yale, and Harvard Divinity School. Dr. Michelson's book, God vs. Gay, The Religious Case for Equality, was a Lambda Literary Award finalist and Amazon.com bestseller, and I believe it is for sale on the back after the presentation. Our discussant today is Ira Carroll, who is also my professor in our class this semester on this issue. He is an adjunct professor here and it litigates on this issue in Pittsburgh and across the country. So we are thrilled for them to both be with us today, and without further ado, Dr. Michaelson.
So thank you. Thanks, Jason, and thanks everyone for coming. As you'll quickly see, in this issue, there's been a lot of heat and not as much light. So actually, to have a conversation like this with folks with different perspectives on the issue, sponsored by two different organizations, is itself really heartening. And also a little bit rare. So really glad that you're here, and it's kind of a pleasure to be talking about this issue. So it's been tough making this presentation because the president and his administration have been changing their minds. I had several slides on the new Trump executive order, which then was not released. The draft that was circulated was basically a very large religious exemption. So as we talk about this issue, this is now at the very highest level of government. It's no longer kind of a peripheral issue as it was when I started about 5-10 years ago studying the issue. And this is actually the way in which, one of the primary ways in which some of the culture war issues, LGBTQ equality, women's reproductive health are being adjudicated in the public sphere. So really briefly, this order was withdrawn, but basically it enabled certain kinds of entities, many entities, to opt out, to be exempted from laws of general application based on a religious belief. Specific religious beliefs were called out in the executive order. Religious beliefs about marriage is between a man and a woman, and religious beliefs about gender, that gender is fixed from birth and dependent on anatomy. And so that it allowed an exemption for all federal employees to provide any kind of services, and also to enable the departments to decline to provide services. Also exempted out any organizations that do adoption or other social services. That's an important issue for Catholic charities. And also for federal contractors if they had a religious belief. So when President Trump announced he was going to continue the non-discrimination order of President Obama, that was welcome news, but then the exemption came along that was so broad that any corporation that had a religious belief could actually opt out from that rule. This order was withdrawn. There's a lot of speculation. Was it, Jared and Ivanka, or was it really ever going to be released, or maybe it wasn't? We may never know the answer. But just I bring this up at the very beginning to say what we're talking about is a work in progress, and very much something that is evolving as we speak, and as I revised the slide last night, because I wasn't sure what was going to happen this morning. So just some of the questions that come up around this issue. So insurance coverage to women, to female employees, that was the issue in the Hobby Lobby case. That was under the Affordable Care Act mandate, which now may or may not apply moving forward, of course. Should government employees be able to opt out of job responsibilities? So Kim Davis, who was on the first slide, the clerk in Kentucky, who didn't want to certify legal same-sex marriages based on a sincere religious belief. And should businesses be allowed to turn away LGBT people? Doctors, that's actually happened. Pharmacists, that's actually happened. Adoption agencies, that's actually happened. So these are very live questions. And as you can see, there's kind of a balance intrinsic in the nature of all of these questions. You could actually put the same questions another way. So on the left column there is the last slide. On the right column, you could just rephrase all of those questions. Should the government compel a religious family-held business to pay for contraception? That wasn't really pay for contraception, it was pay for insurance. But notice that the framing, right, inverts, right, so just the framing, it's the same situation, inverts the sort of the understanding of the issue. Must a religious government employee facilitate a same-sex wedding? Now, if progressives like me, we would say that a clerk isn't facilitating a same-sex wedding, but she saw it that way. Right? Kim Davis saw it that way. So does she have to choose between her job and her religious conviction? Should the government compel religious doctors to refer women to abortion services? Once again, here, when the frame is changed, now it's actually government versus doctor, as opposed to the woman seeking abortion services or reproductive health care, or even counseling or contraception. So just noticing right at the get-go that this is a question of balancing different interests, and depending on how you want to phrase it, if your interest is polemical, if you want to just kind of say how great or how terrible some law is, whether in Indiana or federally or in North Carolina, it's not hard to play with the words in order to do so. So we're just going to look really briefly at where this conflict came from, what does it look like today, and kind of what it might look like tomorrow. So yesterday, today, tomorrow. And I don't know where I got the idea of root, branches, and vines, but it's worked the last time I've talked about it. So just as you heard my bio, just to sort of say, I wear many different hats. And so I try to bring to the analysis of this issue both a kind of religious lens and also a legal lens and a journalistic one. And I think that'll be relevant toward the end, and I'll talk more about that when we get there. All right, so where did this conflict come from? 4 different answers to that. So first, right, obviously the First Amendment, intrinsically, right, is always in dialogue with other rights and interests, right? So no right is absolute. So the Free Exercise Clause is always in dialogue with other government objectives, right? You can't shout fire in a crowded theater, right, about free speech, for example, right? Because there's a safety interest in not having that happen. The Establishment Clause constrains the government. So the same thing which when a Christian prayer group wants to meet in a school, that's a free exercise interest that they have. But then there might be an Establishment Clause interest mitigating against their same meeting in the same school, right? So the Free Exercise and the Establishment Clause are often in dialogue, right? And some of the other examples. I listed animal sacrifice, which may not pop to mind as a pressing issue of the day, but actually that was a pretty important case out of Miami, where there was pretty much it was motivated by animus against the Haitian community, and it was kind of targeting various specific practitioners, and was an example of a government law that looked like it was just about animal welfare, but actually it was really about religious discrimination. And obviously civil rights and non-discrimination, kind of what we'll be talking about today. So the classic free exercise cases, for those of you who may have forgotten constitutional law or the non-lawyers in the room. All right, so Barnett is a really good example. The state can't compel Jehovah's Witnesses to say the Pledge of Allegiance in a school, right? That was actually at the Supreme Court. There was an earlier case which said that they could compel them. The famous case saying that that's actually not something. It was actually more of a free speech case than a free exercise case, but somewhere in between. More recently, a case you might not have heard of, Holt versus Hobbs. There was a Muslim prisoner, and parenthetically, a Muslim prisoner with very strong jihadist kind of anti-American views, which he had written about, who wanted to grow a beard because he was religious. And there was a lot of, because of the prisoner's political views, there was all kinds of stuff in the record that there was a lot of animus and discrimination against him. He agreed to grow a beard that was only a 1/4 inch, and the state still said you could hide a knife in your 1/4 inch long beard. The Supreme Court said that's ridiculous, there's no safety interest here, and found 9-0 for the prisoner. So that's a classic free exercise case. Notice in those cases, there's no third-party harm, right? So in the prisoner case, the prison system wanted to say, well, this is a safety rule, this is a safety regulation, but the court really didn't buy that. And it's a minority religion generally against the state, right? In the classic cases, right? A minority disfavored religious group as against the state. That's very different from the kind of modern religious liberty debates, which we'll be looking at in just a moment. So that's the first of the roots, right? The First Amendment itself. But the second, obviously, are the social changes of the last half century and the rise of what's called the new Christian right as a response. So segregation was the first of those changes in the 50s and 60s. And having lost the battle on segregation, there were a number of efforts to exempt religious academies from desegregation and non-discrimination rules. So for example, actually prior to the 1960s, there weren't that many Protestant private schools. There were Catholic parochial schools, of course, but these actually grew and they were labeled segregation academies that were exempt from civil rights laws because of their sincerely held religious beliefs, and justification in scripture. So there's a line by Bob Jones, Is Segregation Scriptural? An article from the 1950s, right? This strategy came to a head finally in 1983, but really in the 1970s, when the Carter administration and the IRS, under the Carter administration, went after Bob Jones University and revoked its tax-exempt status, saying that race-based admissions policies contravene government objectives and norms, and so we're not going to get a tax exemption if you maintain a racist admissions policy, or later as a racist housing policy. So there's that one interest, right? Civil rights. Other interest, Bob Jones said, this is our sincere belief, right? No one actually said that the university was lying, was saying that actually this is just a justification for racism. They said, no, this is our sincere religious belief. God separated the races on the continents and we're against mixing. And the court ended up going, actually, with the government against Bob Jones University. The reason this was really more important in the 70s, right, is that this was actually the flashpoint, right, the birth of the sort of modern politically engaged Christian right. It's a book by several books now by historian Randall Balmer talking about that. What do we mean by Christian right? We don't mean folks who are Christian, right? We mean a specific politically engaged response to social change that combines the rhetoric of the moral majority with, the self-conception of a moral majority with another self-conception actually of an oppressed minority. So kind of an interesting tension, right? So this is the political Christian right, which has been incredibly important, right? Bob Jones University itself remains iconic. So there's Ted Cruz talking to them, right? George W. Bush at Bob Jones University, Ronald Reagan, and the Republican Faith and Family Forum that took place there about a year ago. So it's not that this is some obscure case that Bob Jones University, nobody cares about that, nobody thinks about that. Actually, it was seen as a real intrusion of government regulation on a religious community that had sought to separate itself out, do its own thing, and have a space that was exempt from laws of general application. So that should sound kind of familiar, right? That there's been a social change, and okay, that's happened, so then there's an effort to have an exemption, a religious exemption from that social change. And notice that really until the 1970s, evangelicals actually wanted the church to stay out of politics, right? It was going to dirty the church, right? And Catholics were actually a persecuted minority who the evangelicals really disliked. There's all kinds of evangelical Catholic animus, and that changed after the social changes of the 60s. So that's the birth of the modern Christian right. And this has been a very successful movement. A lot of times when we think about the Trump election, we're focused on the white working class or rural voters or one specific part of the Trump electorate. But in fact, without the evangelical vote, it wouldn't have been close. I mean, it would have, right? So really, without the evangelical vote, there would have been no, and the conservative Catholic vote, there would be no Trump administration. And so we're seeing that now, right? There actually that's one of the factions within the administration. The Betsy DeVos confirmation vote just happened. I didn't get the news, but I assume it just happened. And coming from that wing of the Trump base. I'm going to skip a bunch of slides, which in a longer introduction, I kind of go through some of the organizations. Alliance Defending Freedom is probably the most important one right now on the front lines of kind of the religious liberty battle. And I guess I'll just bring out that, on the spectrum of center-right to hard-right, the Alliance Defending Freedom and its rhetoric is not toward the center. And it's a much more kind of strongly ideological organization. And the Becket Fund were the lawyers in Hobby Lobby and other players, major players, which I don't have time to go into. So the third root of the current religious liberty debate are the battles over abortion. So in public conception, right, the whole rise of the Christian right was about Roe versus Wade. Obviously still a contentious issue today. I felt funny even typing those words out, since it's obviously at the center of certainly the upcoming Supreme Court confirmation hearings. And the anti-abortion tactics and actions are kind of a template for the current anti-LGBT actions. So let me give you a few examples of that. So first, there were a number of religious exemptions passed in the 1970s, exempting doctors who had religious objections from performing abortion. So let's think of that as an example, because it's going to be important later. I think if we went around the room, even liberal folks like me would kind of say that, well, that makes sense, right? I mean, a doctor performing an abortion, compelled by the state, believes that the doctor believes that he or she is taking a life. If another doctor is available, if it's not an emergency, if the woman's health isn't in danger, I mean, we might think that might be a justified religious exemption, right? So it's not an all or nothing. But then the exemptions grew to include not just nurses and hospitals, but entire health systems. Right, such that actually the accessibility to abortion is severely limited by some of the religious exemptions. So notice that while it's often a question of scope and scale. We'll see that in just a minute. So that's one way in which the current debates were shaped by the abortion battle. Also, as I mentioned, the Conservative Catholic Protestant Alliance, which had been really unheard of. Just a fun fact, Jonathan Dudley's book, Broken Words, talks about how early on it was difficult to get Protestant evangelical support for the anti-abortion rhetoric because they saw this actually as kind of papist Catholic dogma, a really forgotten chapter in history, that it took a lot of persuasion. Now, of course, that's not true at all. They're leading evangelicals right on the front lines, pro-life movement. So third, one way in which the exemptions movement has worked is by withholding affirmative government actions. So maybe it's funding in case of the Hyde Amendment or clinic certification. And this, I highlight this in yellow for a reason. I want to bring out the point that these restrictions don't just limit access to healthcare, but they limit the conception of the right itself. And that, I think, is an important piece to think about when we look at the balancing questions on LGBTQ equality, right? If we have a bill, which we will, most certainly, within a few months, limiting marriage recognition, that doesn't just limit same-sex couples' rights to access certain services and benefits. It changes the conception of the right itself, that it's something less than full marriage, right? And I think we can see that with all of the restrictions that are in place around reproductive health care. It's sort of a right, but not exactly, and and that actually, I think, is a really important piece to consider, that it's not just access to the wedding cake or whatever the particular example is, but it's the dignitary harm of saying, no, you will not be served here, and a reconception or limiting of the underlying right in question. So that I want to really kind of bring that out and highlight that. Finally, moving the chains, right? So with the Hobby Lobby case, which I'll talk about in a moment, and cutting funding for family planning internationally, now we're actually talking about contraception, right, rather than abortion. And Hobby Lobby kind of fudged that a little bit by saying this kind of contraception were abortifacients, but really we're talking about contraception. So moving the chains has been actually a very successful strategy in the abortion side. Fourth of the roots of the current, obviously, is the social change around LGBT equality. I won't spend long on this because I think we're probably aware of it, but there's been a pretty significant social change and legal change and cultural change in the last 10 years. So is what's happening now a backlash? No, I don't know. I would see it more as a shift in tactics. The opposition began well before any of the recent victories of the LGBT movement. The exemptions tactic, which had been used in other contexts, is now being used in the LGBT context. But I also I think it's really important to remember the multiple narratives in play, that there's a real perception of victimhood, government compulsion, and a need for accommodation. And that's not just rhetoric, that's actually a real perception. So what does the battle look like today? I'm going to go a couple of minutes over that, I think. So religious exemptions we've talked about already, balancing equality interests against religious freedom interests. So there's a law of general application, like a non-discrimination law, and then exemptions for religious actors. So here are two challenges with that strategy. The first, I would argue that the public demonstrative harms undermine equality itself. If there's a swimming pool that's only open to Gentiles, that's closed to Jews, it doesn't matter that there's another swimming pool that the Jews can use. And if there's a florist or there's a company that says no gays allowed, the fact that there might be another pharmacist or doctor or hospital right down the street doesn't affect the public demonstrative dignitary harm to the equality norm. When we have signs like this, the equality norm is harmed. Right? And that, I think, is a real challenge to the exemption strategy. And then, of course, the question of scope. So who should be exempt, whether it's labor laws or others? So churches, seminaries already have pretty much a blanket exemption. If I'm a gay person who wants to be a Catholic priest, the Catholic Church gets to decide for itself that that's not going to happen. An out gay person, obviously. Well, what about religious organizations? Been a couple of cases about that, including one this year. A little bit hazier, but probably also getting a pretty significant religious exemption. Well, what about religiously affiliated organizations? So the LDS Church, the Mormon Church, has enormous real estate holdings and commercial real estate holdings. If they're owned by the Mormon Church, that's sort of a religiously affiliated organization. So should the government be telling the Mormon Church what they should be doing in their own property? I don't know, but on the other hand, that's a lot of property that otherwise is exempted, that could be exempted from anti-discrimination law. Well, what about for-profit businesses? Under the Hobby Lobby case, if it's a family-held business, that too can receive a religious exemption. So corporations are people, and corporations are people with religious beliefs. And finally, what about individuals, right? So Kim Davis, the poster child for the religious exemption movement, was found in contempt of court, but the First Amendment Defense Act, which has been introduced and is likely to pass both houses of Congress, absent a filibuster, will change that, right? We talked about that in the very beginning, in which case Kim Davis will ultimately have won. So it's a question of scope a lot of the time on religious exemptions. Second of the four branches is the Religious Freedom Restoration Act, or RIFRA, which started out as a liberal cause. I was actually working for Congressman Gerald Nadler on the Hill when RIFRA was passed in 1993, which gives you an idea of how old I am. And it was actually seen as a progressive point of view because the case was about Native Americans who had basically been penalized for their use of peyote sacramentally, right? So RIFRA requires, not to get into the weeds too much, right, a compelling state interest and least intrusive means. Makes it very hard to burden religious freedom, right? It shifts the balance of the First Amendment civil rights balance a bit more in the favor of the religious practitioner. So normally, for about 15 years, these cases were not used, RIFRA was not used in cases of third parties. So when the Native American is consuming peyote, that's basically, there's not really an articulate third-party harm. Well, maybe if they're intoxicated at work, certainly, right? But that wasn't even the case at that point, right? The classic case was like Smith, a minority religious group not affecting anyone else, right? But that really changed in 2014 with the Hobby Lobby case, where the Supreme Court ruled that a closely held corporation could opt out of the contraception mandate of the Affordable Care Act. Well, there is a clear third-party harm, right? The female employee who's not able to receive the contraception care that she would ordinarily get as under insurance. Supreme Court said there's another way to do this, so it failed on least restrictive means grounds. This was the first time that the Supreme Court applied RIFRA when a third party was affected. So that was a real revolution in RIFRA and how we understand it. Turning religious liberty, I would argue, from a shield to a sword and applied to a majority religion. So today, when Mike Pence went on Nightline, or it wasn't Nightline, it was George Stephanopoulos, and said, this is the same law that President Clinton signed, and this is a great law. Well, textually that's the case, but in application, RIFRA is now very different from what it was in 1993 for these reasons. And they're spreading throughout the country pretty quickly. So on the other hand, RIFRA is still depicted as a shield because it is a defense against government action. Right? So those who are backing it say this isn't a sword to use against third parties. This is to protect religious actors from the government, and that it's a rebalancing of interests. I don't really buy that perspective because I think, the reality is the same people making these claims were in fact working to reverse the underlying legal changes. So it's difficult for me to take at face value the notion that this is a defensive posture when the same people making the argument for the defensive posture were making offensive arguments to try to actually undo the underlying legal rights. So the third, and I'll go over a little more quickly on these last two, marriage facilitation. Here are some examples of ways in which there are going to be limitations on marriage facilitation in the case of religious objections. The kind of poster child case for that is this case of Elaine Photography, which was a closely held business, that's the couple who owned the business, who did not want to take a photograph of a same-sex couple. It wasn't actually at a wedding, but a wedding picture of a same-sex couple. And this was kind of the poster child. It's an interesting poster, literally. It's not really the price of citizenship, right? It's actually the price of doing business and holding out a shingle and agreeing to adhere to the rules of the market. So if Elaine Photography, the couple in Elaine Photography had said, I won't take a picture of an interracial wedding, is that really compromising your beliefs, or is that obeying the non-discrimination laws that are part of the agreement of doing business? So that a little bit of conceptual slippage maybe, even in the poster child case. So the photographers feel they're being forced to violate a religious belief, but should a gay couple feel that they shouldn't be turned away, right? I mean, do we really think that there's not a harm saying, here's a historical example, we wash for white people only. Even if there's a religious motivation behind that, I think a lot of us would have trouble saying that doesn't offend our equality norms in our country. And the real challenges really aren't about wedding cake bakers. It's really about employment benefits, denial of services, much larger examples than just a couple baking a wedding cake. But you'll hear that example over and over again. It's easy to get your mind around, and it's a close case. It's a much harder case than some large corporation not wanting to recognize an employee's marriage. So just some, I think I'll close with this part, and we won't do the vines unless we get to them later, sort of how to move forward. So just some real life examples to think about. These have all actually happened. A pharmacist refusing to dispense HIV meds to a gay person, including HIV meds which might be necessary right in the moment. A rape victim denied emergency birth control because the hospital is affiliated with a religious organization. Doctor refusing to treat the child of a lesbian couple. This case happened in Ohio, saying that was her religious belief, and there was another doctor available, so they should see the other doctor. Or a religious organization covers up child abuse and is actually then exempt from prosecution under a Religious Freedom Restoration Act. And that's happened as well. And it's happened for individuals as well as that. Or school guidance counselors saying, I have a religious belief that homosexuality is wrong, and so I won't counsel a gay student except to say that they should enter reparative therapy or conversion therapy. So these are challenging, I think, cases to actually think about the application of the balance between the religious liberty interest on the one side and the civil rights interests on the other. And I think it's helpful, just to, since I won't be doing part 3, more examples. Since I won't be doing part 3, just to think about the ways in which the multiple narratives can be understood in the context of this conflict, right? There's a sincere belief on both sides that they are the victims of some kind of harm, whether it's discrimination or government laws that actually ban discrimination. And that should be taken seriously. And the fact that there are competing interests on both sides doesn't necessarily mean that we can't adjudicate between the two. And that there are interventions that might happen on a religious level as well as a legal level and on a social and a cultural level, which maybe could be more effective than the polarizing rhetoric that you see both on the left and on the right. That this is nothing but a pretext for prejudice or homophobia on the left, you hear that said, and that this is religious compulsion, which is often said on the right. Last slide. It was a great little moment with my former boss, Congressman Gerald Nadler, and Matt Staver from the Liberty Council. So Jerry said, suppose a photographer said he shouldn't photograph a Jewish wedding. And he said, well, I don't think that would really happen. And Congressman Nadler said, well, what if it did? And there was an agreement, well, that would be an issue. That would be a violation potential, meaning a violation of their religious liberty. So I'm wary of the slippery slope argument too often because it's just kind of a scare tactic. But it is helpful to just conceptualize that when the balance is shifted in this way, the consequences, the unintended consequences can be even greater than the intended ones. So looking forward to hearing from Ira and from your questions in just a minute.
So first of all, I want to echo Jay and Professor Hammoudi in thanking Outlaw and the Christian Legal Society for co-sponsoring this event. It's certainly something that is very important, timely, controversial, and sensitive. And it's really impressive that your organizations are working together on it. I think it's a testament to you and a testament to this fine institution. And I appreciate the opportunity to participate. I'm going to stay out of the political aspect of what Jay talked about. It's not really my thing. I'm a professor of freedom of religion, and I'm a practitioner who has clients on both sides of the aisle. I don't do politics. But I want to talk briefly about my baseline, where I come at this from, and 3 points that Jay raised about previous cases that I think are inaccurate, and then open it up for you guys for questions, because we really want to have a dialogue today. So first, my baseline. Where do I come at this from? You have legitimate, constitutionally protected rights on both sides of this issue. The 14th Amendment protects LGBT rights. The 14th Amendment protects women's rights. The First Amendment, in explicit terms, protects religious liberty. It does. And at the end of the day, when those things conflict, someone is not going to get full protection. And that is tough. It's frustrating. It's going to offend whoever doesn't get their full protection. When there isn't someone on the other side, you get pretty good protection. When there's someone on the other side with a constitutional right, you don't always get full protection. And where I come at this from, my favorite professor in law school, Martin Reddish, who's a pretty renowned scholar, always says, if your interpretation of the Constitution aligns perfectly with your political preferences, you're fudging the Constitution. Because the Constitution is not on the left and is not on the right. The Constitution sets out principles, and it asks the Supreme Court to establish fair, neutral tests to determine when one principle wins and when the other one loses. And as Jay said, the best tests have to do some balancing, because neither side is going to win every time. And that's why I like the RIFRA test, the federal RIFRA test, not some of those state ones that go further. It's based on pre-Smith case law. There's a lot there to work with. It gives people predictable outcomes in most cases. It is not perfect. There's line drawing issues. But to give you a couple quotes, Justice Blackmun says, the way we treat everyone equally in this country is not by giving them equal outcomes. It's by giving them, he says, an equal test. They get uniform application of the compelling interest test, not reaching uniform results as to all claims. That means the 14th Amendment claim is not going to win every time. And the First Amendment claim is not going to win every time. What's going to happen is we're going to have a neutral test that's going to balance them out, and it's going to come up with some situations. Everyone can agree clergy doesn't have to perform ceremonies. Everyone can agree you can't put up a sign at your pizza place that says no gays allowed. What do we do with everything in the middle? We have to balance. And the balancing test in RIFRA is a good one. It's not perfect. Justice O'Connor said, courts have been quite capable of applying our free exercise jurisprudence to strike sensible balances between religious liberty and competing state interests. And I think that's the test we should be applying here. So what is the test? First of all, it starts off by asking about the religious liberty. What is your belief? Is your belief sincerely held? Is your belief burdened? Meaning, does the government require you to do something? Is there some sort of penalty, some sort of withholding of a benefit? And does it require you to take some sort of action or prohibit you from taking an action? And that's an important one in the contraception cases. Because if the government said, we're funding Planned Parenthood, if the government said, we're going to fund contraception directly, the Catholic Church has no objection. But when the government says, your health plan, and you're either paying, there's something called self-insured plans, where without the accommodation you actually pay for the contraception people use, or you have to sign this form. We pressed the government on it, the Supreme Court pressed the government on it. You have to sign this form for it to work. The government says it cannot provide the contraception to the women through the plan unless the Catholic Church signs a form. And under the precedent, that is a substantial burden. Doesn't mean it wins, but it's a substantial burden. And the court's first step is to say, you have a substantial burden, we respect you. Then it shifts to the competing interests, right? What's the compelling interest? Is the least restrictive means. And that is a test that works. Courts get into the balancing. The Bob Jones case that Jay mentioned is a great example, and it's really important here. But it's also limited. So in that case, you have racial discriminatory policies in the school because they have a belief against interracial dating and marriage. And the court says the law taking away your tax-exempt status burdens that belief. It does. But you still lose because the government has a compelling interest in eradicating racial discrimination in education. The court said we have a history in this country of institutionalized racial discrimination in education. Education is important in influencing the next generation. No less restrictive way to get rid of it than to ban it, so you lose. But the court was very clear that it wasn't talking about churches, and it uses the phrase, other purely religious institutions. So for these cases that we're talking about, when LGBT rights conflict with religious rights, when women's rights conflict with religious rights, the caveats in that case are going to be really important. What are other purely religious institutions? How are they different from education? Do we have institutionalized discrimination against women? Do we have institutionalized discrimination against LGBT rights? Those are going to be some of the key arguments that are going to come up, and it's going to be case-by-case balancing, and it's going to be hard. And that's okay. I think that's a good thing. I want to very briefly touch on 3 things that Jay put in the RIFRA analysis that I think are not accurate. One, when he had circles about what's the protected right, individuals were in the last circle, right? Churches were in the middle, individuals were out here with for-profit companies. The core of the First Amendment is protecting individuals. It's an individual liberty. Madison's Memorial and Remonstrance is the basis for the First Amendment, 1785. It's all about individual liberty, an unalienable right. The cases are all about individuals. Sherbert's a Seventh-day Adventist. Yoder's a group of Amish parents. Thomas is a Jehovah's Witness. I get it. Kim Davis can be scary. But the fact that someone's scary means they're probably going to lose on the balancing part of the test. You don't have to cut them off at the first part. And if the court was willing to give Bob Jones University the first half of the test, I think we could give Kim Davis the first half of the test. Second point is majority religions. Basically said before 2014, majority religions never won. They never made claims, they never won. And it's sort of implied, he didn't go that far, it's sort of implied that they're excluded from RIFRA. They can't state a claim, right? But that's also not true. First of all, that would violate the Establishment Clause. Congress cannot pass a statute that says we exempt some religions and not others. It can't do it. It's the inverse of saying we only exempt majority religions, right? We only exempt Christians, not Muslims and Jews. Clearly unconstitutional. The inverse is equally unconstitutional. It's also not accurate. There have been cases throughout the line that find in favor of Christians. Frazee, 1989. right before Smith, found that a Christian who refused to work on Sunday, because it was their Sabbath, got an exemption. And the last point is about third-party burdens. Again, Jay said no cases before 2014 found exemptions when there were third-party burdens. It's part of the test. Third-party burdens go in the balance, goes in the compelling interest. Courts have found that there is no exemption in cases, in part based on third-party burdens. It's a factor, no doubt. But there have been cases where the court said there are third-party burdens, and there is still an exemption. The most extreme is Yoder. You have Amish parents, Wisconsin, they say, we only send our kids to school through 8th grade. Law says they got to go till they're 16. The dissent says, you're hurting the kids who leave the community. You're hurting them. They don't have an education. When they leave their community and they don't have this agrarian society, they don't have anything. And they fail, and they commit crimes. You're hurting them. The concurrence says, you're right. But I have to balance that. And I balance that, and I say, tough for them, because of the strong interest here. There's cases granting people exemptions from the draft for Vietnam. There's a statute there, but they grant exemption from the draft for Vietnam. Other people went to war instead of those people. That's a pretty significant burden. It's not paying for your own contraception. It's going to war. And in the unemployment benefits cases, the employer and the state have to pay for that person's unemployment, right? If you get fired because you didn't show up to work on Saturday because you wanted to hang out with your kids, no unemployment. Because you're Jewish or Seventh-day Adventist, unemployment benefits. It's a burden. It's a burden on your co-employees, right? Because what's the incentive after that? You're gonna have to pay someone who you trained to not work and hire someone to replace them. Or you could just put more Saturdays on the rest of your employees. So to me, when we strip those things out, what we have is a really good balancing test that allows us to navigate between these interests. It says there are going to be times where religion is going to win. It's going to happen, and it should happen. And there are going to be times when LGBT rights and women's rights are going to win. And it should happen that way. That's good. And there's going to be gray areas in the middle that we're all going to struggle with. And that's also good, as long as we do it in a respectful, positive way, and we apply the same neutral test that we've always applied, and at the end, both sides can at least come out feeling like, I lost a few of those, but my rights were respected and balanced. And to me, that's what the Constitution demands of us. Thank you.
Okay, so now we're going to go into our discussion part of the program. Seriously.
So we're going to move the mic.
Should we just stand back here?
They want us on there, so we should take the mic with us. I was just going to turn this off.
And you start. Okay. Did you want to go first, or?
You can go ahead.
Okay. So,
If
Oh.
it's fine. Yeah. You got it? You got him? Great.
okay, this is good. So going back a little bit to the political questions that you were raising, I think a lot of us are seeing significant movement, not only in U.S. Congress, but also at the state level for enhanced RIFRAs. I do a lot of work in advocacy in Harrisburg, and we just had the introduction of a student RIFRA, religious liberty bill. So I was wondering maybe if you could talk a little bit about your pulse on where these things are going in legislation, and you know, how you know, in addition to the courts that we're talking about, what's the prospect for legislation?
Yeah, I mean, it was interesting in the there was a run-up, there was a brief period where it looked like we might have a federal Employee Non-Discrimination Act covering LGBT people, and the Human Rights Campaign, the largest kind of mainstream LGBT organization, was pushing for it, and it actually had a RIFRA-like exemption. Like, there was a pretty large religious exemption in it, and I had met with them at the time, and I was like, this exemption, that would be an unprecedented exemption, it's really not worth having the bill if we're going to have this big of an exemption. And they said nobody cares about religious exemptions, but that was false. That spring, that bill lost a couple of its key sponsors, fell apart. I think now everybody cares about religious exemptions on the left and the right. So there's certainly a lot more visibility that's there. And it's been, one of the things I didn't get to in mind, that the factors that have tended to determine the outcome on a state-by-state basis are not how strong the people on each side think. Feel about each issue. So, for example, in Texas, an enhanced RIFRA was killed basically by the Chamber of Commerce pro-business Republicans over the objections of the more religious Republicans. So that was an intra-Republican fight. Same thing in Georgia, where Coca-Cola kind of threatened to come in. Because if I'm an employee, if Coca-Cola is competing for the best employees, they'll face a real incentive if I feel like I'm unsafe, I can be turned away from businesses, I can be fired if I work in Atlanta. So it's actually been the business community that's led most of the successful opposition to RIFRAs. Obviously, the most clear example of that was Arizona, where the National Football League, of all people, basically helped kill the RIFRA in Arizona, and it got turned to, it's tricky for people like us who want to have thoughtful conversations about these things, because I also want victories. So, if we're going to call it the kill the gays bill and turn away the gays bill, and we're going to win. Well, I do want to win, but obviously it was more about characterization, that the Arizona bill and the Indiana one were somehow seen as worse than other ones, which are on the books in other states. So it's been almost random, based on who gets involved at which stage of the process, how these things go through. And I think we would probably agree that that's not necessarily the best way to make policy. Who gets their act in line to get their largest corporate backers or opponents to the bill.
Thank you. Thank you. Professor Carroll, quick question for you. Just for those who are unfamiliar, could you provide the framework of how the federal RIFRA works, what the steps are, so that we can better understand what the process in court looks like when we're talking about these issues?
Yeah, sure. So, first of all, one thing I forgot to mention before, right, was RIFRA passed almost unanimously, right? There were many people on the left who supported it. There seemed to have been equally people on the right, right? It was almost unanimous. So, and I think that's because it's a good balance. And I think these state laws that go further are pretty dangerous, because they're trying to strike an ad hoc balance to achieve a goal. But the way it works is the plaintiff comes in, the person who's saying I have a religious belief, you have to show a substantial burden on your religious belief. So you have to show, number one, that you have a sincere religious belief, it's sincerely held. The government almost never challenges that. But one litigation thought, especially as you start to get into claims about whether someone really means it, does someone really exclude, if you have certain Jewish beliefs on marriage, right? Jews can't marry non-Jews. Two men can't get married, a Jew can't marry someone who didn't get properly divorced. So if you have someone who's not going to make a cake for anyone in those categories, maybe that's a pretty strong, sincerely held belief. But that's a fair question to ask on cross-examination, right? Do you make cakes? You say you don't want to make cake for two men who are getting married. Did you make one when that Jew married a non-Jew? Because that also violates your beliefs, right? And I think you can press them on sincerity, because I think part of what Jay was raising was maybe for some of these people it's not sincere, it's just discrimination. But there are people for whom it's sincere. And I think that sincerity is important. The government almost always concedes it, but if you're in a case, you don't have to. There has to be some action required from the person or something compelling them not to act. So, to go and do something is different than if the government does it itself. If the government says, we recognize two people as married, you don't have a complaint about that. There's no RIFRA claim. And then once you've shown those things, and there's some sort of compulsion from the government, either a fine, withholding a benefit, then the other side comes in and shows their compelling interest. If they have a compelling state interest, are they using least restrictive means? And then the courts go in and balance it. And they figure out, is this really worth it? Is the punishment severe? How does this work? And you come in and you bring in your evidence, and you have to support what you're saying. We talk about it in our class, there's some cases where the court says, I need a lot of evidence. Bob Jones University, the court didn't really need much evidence, right? It's pretty obvious that we have a history of institutionalized racial discrimination. We have to eradicate that. And so some of these cases there may not be the same need for evidence, and some of these cases there will be. And if you're litigating, I think you'd want to plan to get maximum evidence. Get as much in as you can.
So, yeah, I guess so, now's a good time to respond to like the characterization of RIFRA. Obviously, I'm not a fan of the balancing test for a number of reasons. So first, I think all of I don't want to say it's disingenuous, but I think it's a little misleading to talk about the unanimous support for RIFRA in '93 because it was understood as a shield for unpopular minority religions. I get, of course, it applies to everybody, right? Obviously, and I would never suggest it doesn't. But it was understood as cases like all of the ones that you mentioned, which were marginal, whether it's the Amish or whether it's Seventh-day Adventist or whether it's a Native American, and it was seen as yes, granted, when you get a draft exemption, there is a diffuse third-party harm because somebody else's number is called instead of yours. But there's not a targeted state-sanctioned discrimination against a particular right, as there is in the third-party harm cases now. So RIFRA in '93 versus RIFRA in 2017, to me, are totally different animals. And when Justice Blackmun or Justice O'Connor talks about the balancing test, and says this is a good balancing test, there again, in the overwhelming majority of those cases, it was a disfavored religious practice that was given protection and no discrete third-party harm, no targeted, articulated third-party harm. So even if it's a photocopy of the federal RIFRA was limited. It was meant to be kind of universal. It was limited by a court case, so now that's why there are all these state RIFRAs. Even if it's a photocopy of the federal RIFRA, what it's come to mean now, I think, is really problematic. And I guess the second difference I would have in the way you just characterized it is, sure, yeah, this is how RIFRA works in litigation contexts, but how it works actually in practice. Let's again, I don't want to get distracted by the wedding cake baker. Let's say I'm running Exxon, or which has a history of anti-LGBT discrimination, right? Now our Secretary of State, obviously, right? And I don't want to recognize same-sex couples for the purpose of employment benefits. There may or may not be litigation about that, but that policy setting at the beginning, right? That change in the set position. If I can articulate that Exxon has a religious belief, as well as not just its employees, but Exxon has a religious belief, just like Hobby Lobby does, and we know Hobby Lobby was a closely held corporation, Exxon's not. All right, but if I can make that case, so now I've changed the starting position for thousands, if not tens of thousands, maybe hundreds of thousands of people across the country. So I'm actually, the way in the sort of classic case like Elaine Photography, where there are these two photographers who I believe are sincere, who aren't, unlike a lot of folks in the LGBT activist side, who just want to call them homophobes and bigots and this and that. I don't think that's fair I don't think it's accurate. Forget whether it's fair. It's just not accurate to describe their religious belief. But there is that dignitary harm of saying, you can't come here. I guess this is my third difference of opinion. You can't come here. We won't serve you. We won't do this. We won't do that. And it's not just one Kim Davis. I'm not scared of one Kim Davis in Kentucky. I'm scared of every clerk in every county in Alabama, except for maybe some of the urban centers. And that I am scared about. I'm scared about my marriage, right? I'm legally married in the state of New York and under the federal government, that my marriage, just like a woman's right to reproductive health care, can't actually be realized in huge swaths of the country. So I can't travel in various places if there are corporations and businesses and government clerks and others who won't actually respect what should be my legal right. So there's the dignitary harm and there's the actual harm. It's not one Kim Davis. There's thousands of Kim Davises. And I think I'm blending RIFRA and exemptions here, so I sort of apologize for that. But that's the dynamic, I think, isn't necessarily how it goes in one particular court case, but how it changes the set positions and what a right actually means when you can't actually enforce it.
So I think just to respond to a few points in there, and I agree with a lot of what you said, but I think, first of all, the debates on RIFRA when it was enacted, there was discussion about Catholic hospitals, right? We actually quoted that in our contraception case. It's quoted in the briefs. And some of that discussion came from people in charge of the ACLU. So it was not designed solely for minority religions. But I think one of the things Jay said that I want to pick up on is he said disfavored religious positions. And I think, in the contraception case, one of the things we heard a lot was over 90% of Catholic women use contraception. Well, to me, that means that the Catholic Church's position is a disfavored minority position, right? There's a lot of places where someone's saying they're against same-sex marriage. That's a disfavored religious position. I think maybe some people disagree whether it should or shouldn't be, but it is a disfavored religious position. And I think that's part of the challenge here of stepping out of our own preferences and biases, is to be able to recognize that there are religious people in this country who feel like their religious rights are not going to be recognized in some states. And there are LGBT people who are saying, my marriage is not going to be recognized in some states. And that is a conflict. And both of them, in some situations, are going to be scaled back. I think everyone can agree that if you go to a clergy member who doesn't want to perform the marriage, I think everyone can agree there's the same harm. Someone looked at you and said, I'm not going to perform your marriage because I don't think it's valid. It hurts in the same way, right? But I think we can all agree that that one we're willing to let slide. And I think on the other side, I think most people can agree that if it's just a pizza place and the guy says no gays allowed, that person's gonna lose.
Why does he lose under RIFRA?
Why does he lose?
Yeah. Yeah.
Okay, it's a fair question. I think there's a compelling state interest in that person's personal autonomy. It's a status crime. You're punishing someone. You don't have to do anything that helps them. You're not using your artistic talents, not doing any of that stuff. There's a compelling state interest in eradicating that kind of discrimination against LGBT people. And there's no way to get rid of that and eradicate that without saying, you have to serve this person.
Couldn't the pizza parlor owner say that it fails on least restrictive means? I mean, there's another pizza place right down there. Why not just have why not require him to say not just no gays allowed, but a longer sign? No gays allowed because of my sincere religious belief, Leviticus 18:22 rules. All right, so let them, now it's more narrowly tailored. Why doesn't the government have to provide that exemption?
Because the narrow tailored option, this is crucial, has to achieve the interest. The interest is eradicating the discrimination. In Bob Jones, they didn't say there's 3,000 other universities in the country, right? They said, we have an interest in eradicating racial discrimination in education. The university loses. There is no less restrictive means.
So you think Kim Davis would lose also under a RIFRA?
I think if you could frame it up right, I think there's a very good chance that she would lose under RIFRA.
Okay, so your RIFRA is different from everybody else's RIFRA, because Alliance Defending Freedom, Liberty Counsel, Liberty Counsel certainly thinks that under any basic religious exemption, or certainly a RIFRA applied to government employees, that she would prevail. I mean, that's why they're pushing for it. What's a case where someone would lose? What's a case where the LGBT person would lose under your RIFRA?
So what's a closer case? I'll give you a closer case. I think the photographer is a closer case. I think the photographer, let's take it out of completely not analogous. I cannot stress enough, not analogous. There are situations in which photographers can say no. This is not analogous to same-sex marriage. Can we all agree? Okay. The KKK is throwing a party. We're going to celebrate our history of cross burnings, scaring Jews and people of color. Right? Best photographer in town, greatest eye, captures the light, is an African-American Jew. In America, does that person have to go and take the pictures? I think the answer is clearly no. Now, I said it's not analogous, right? What that means is there's a balance. And there is a time in which we're going to be able to say a photographer says no. A photographer says, my talents are helping you enhance your event, and I don't agree with your event. But I think we're going to need a lot of evidence. And what I find with a lot of the people who litigate these cases is they're kind of these theoretical lawyers who are appellate lawyers who don't deal with facts. And these cases are going to be so fact-driven and so fact-heavy. And I think part of the reason we're having these discussions and they're so much open is Justice Kennedy's decision in Obergefell. Because Kennedy likes to make these kind of fact-specific determinations. He doesn't think we can have categorical rules. And so the dissent pushes him. You have to tell us, what's the bounds? Where's religious liberty going to line up? And he says no, because he wants to get into the facts. And I think that's going to drive it.
So is there a case that's not a First Amendment expressive business where the LGBT person would lose under your conception of RIFRA?
It's not a First Amendment
So
expressive.
pharmacist, what about the doctor refusing to see the child of the lesbian couple, that Ohio case?
I think that doctor loses.
So again, I mean,
I think
like
you're going to have to marshal your I think
but-
the challenge is you're going to have to marshal your evidence. If you look at our contraception case, the government did not marshal any evidence. We brought in witnesses. You know what the government lawyer said from the DOJ? We stand on the administrative record. Judge Schwab said, do you have any evidence? No. We're good. Administrative record. He sat down. You're going to have to work. These are hard cases. These are cases that require the kind of judging that we trust our judges to do. But we're going to have to, if you want to win these cases, you're going to have to marshal a lot of facts. You're going to have to show that a doctor saying no, what's the harm? How did they win Brown v. Board of Education? They didn't come in and say, well, it's mean. It hurts people's feelings. They brought in hundreds of pages of social science evidence to show the harm. If you want to win and show you have a compelling interest, and that there's a compelling interest in eradicating discrimination, you better come in with facts.
All right, so I'm not trying to make light of it, but the way you're characterizing RIFRA is different from, I've had these conversations with folks from the Beckett Fund, with folks from Alliance Defending Freedom on this kind of a panel, and they understand RIFRA very differently from how you understand it. They understand it as providing, as Kim Davis would absolutely win, the doctor would absolutely win, and I agree, and I want to grant that the First Amendment expressive businesses like the wedding cake and the wedding cake and the wedding photographer are closer cases, but I also think they're actually, normatively speaking, more the outliers. And the reality is, my partner and I were looking at adoption, and we can't adopt kids from half the states in this country, let alone half the countries in the world. We can't use the largest adoption agencies that are available in several states. So it's that may not be a dignitary harm that's obvious, like whites only signs, but I feel it, and it's not just a hurt feeling. It indicates it's a very clear. It is a fact that my marriage right is not equal to other marriage rights because of the very large size religious exemptions that Catholic Charities has fought for and won. So while I like your RIFRA, we can agree, and it's like but in reality, unfortunately, the folks who are really pushing these laws have a much more expansive view of them.
To continue the conversation, I think we have time for a couple questions from the audience. Yes?
Yeah, sure, 5 minutes.
Okay, great.
Don't worry about me. Worry about them. The pizza's getting cold.
5 minutes.
Tony?
I have one, Professor. I thought it was interesting that you said you didn't want to get into the politics at all of this. You were looking at it straight on. I just thought that was really interesting because I'm an LGBT student, and I feel like our marriage has been politicized, our adoption, most recently, where we use the bathroom. So how do you look at this without looking at it through a political lens?
I think that's what the Constitution asks courts to do, right? I think we have several spheres in this country, and there is a political sphere, and that is a fight that should happen on both sides, and I think there are people fighting it, and Jay is fighting that fight, right? I'm not involved in that fight. I have no expertise in that fight. Where I have expertise and experience is what happens in courts. How do judges view this? How do professors view this? And how do you win a case? If you're trying to win this in court, how do you win it? That's what I have experience with. And so I can't inform you. You know more about the politics, frankly, than I do. And it would be unhelpful for me to talk about it. But I think I have some insights on the legal side. So that's kind of where I approach it. The courts should not be looking at it politically. Do they? In some chambers? It'd be hard to deny it. But I think most judges, when they get cases, try to weed out their biases. Now, what happens at the Supreme Court, only people who've been there know. But it's certainly in the lower courts, the judges try to weed out their biases. You get some clerks who disagree with you, and you talk it out. And that's where I come at it from.
Hi, since I'm not in law school, I don't know if many of you know me, I'm Adam Scher, I teach in the Religious Studies department here. I have a kind of, it sort of is on the sort of intersection though of the political and the litigation. I really actually appreciate these two different perspectives, not only coming, let's say, from different points of view on it, but in a sense, a kind of meta and global perspective from Jay and from you, Professor Carroll, the kind of the litigator's view of this in the ground. I think it's probably pretty interesting to the law students here, especially. But it seems to me on two kind of key issues, inevitably a kind of political sociological judgment has to be made even at the litigation level, and that's kind of where I wanted to kind of press both of you, sort of to think about this maybe. The question of majority, minority, or unpopular religious beliefs that can be marginalized even if they're held by a church that's a very large denomination. This fits right into a kind of a theme in American religious history over the last 50 years of evangelical Protestants and increasingly the Catholic hierarchy, at least, if not in some conservative Catholics, right, thinking of themselves as a kind of countercultural move. It's countercultural to be a faithful Christian in our overwhelmingly secular society, and one hears that kind of rhetoric all the time, even invoking early Christian themes, themes from early Christianity, pre-325 CE. I always love to put in a 315 CE, actually a 4th century reference in the law school. But in other words, I'm wondering then, doesn't that, as part of the claim, end up having to be sort of adjudicated then in the judicial sphere? The second way I could sort of see that emerging from the political, sociological, cultural side, and then having to be adjudicated. And obviously, that huge set of documents you referred to in Brown, were coming from social scientists and historians, and not from legal scholars. Is this question about third party, this question about third party harm? I don't have the legal language, diffuse, concrete, but it does strike me that the way that the harm would be felt in terms of the dignitary harm would change with the changing social and cultural mores when we're talking about either real people or an abstraction, the theoretical gay person, right? And so that sort of as a matter of empirical record, right? Something that an LGBT person might, when you say T in the 1970s, right? A lesbian or gay person in the 1970s might shrug off as, we're never going to get there. To now, as the social mores change, doesn't the sense of dignitary harm arise, right? So we can't necessarily view it in the abstract. We need to mount that kind of evidential base of the cultural, social questions.
Well, there was an argument about that in the marriage cases, where the LGBT side was trying to say we're a small disfavored minority, and the other side is like, what are you talking about? You just won this whole run of cases. You're not really that small and disfavored anymore. Like, times have changed. But there's definitely,
So
there's
two examples coming by.
There's an interesting a slide I didn't get to was on the Georgetown case and providing women employees contraception coverage. And the framing determined the outcome on public opinion. So if you ask public opinion, should a Catholic university be compelled to provide payment for contraception? Basically it was 60-40 saying no. But then if you asked it, should a female employee of a Catholic university receive the same rights as everyone else or something like that, then it was 60-40 yes, right? It's the same fact pattern, just characterized in two different ways depending on how, on the perception of who's the victim. But, it is, I wonder about I wonder about giving that too much weight, though, right? First of all, we changed, public opinion shifts its mind, and that's not really where the law should be headed. But second, there's just not a lot of cases yet of Christian bashing by gays, right? There's those bullying cases where, like, the Christian student can't wear the T-shirt that says, God hates fags or something, and that's seen as the same kind of oppression as the gay kid getting beaten up by the bullies. And I'm not really on board with that kind of equation. Like, I don't think it's the perception of victimhood, and that perception is real, right? That is not. When I started doing this work a few years ago, I was like, this is just BS that people think they're really being targeted. And no, it is a sincere belief that many evangelicals and conservative Catholics have, and it's based in reality. If you look at the number, the growth of the nuns, the NONES, those who have no religious affiliation, the sort of shifts in American religious consciousness, that may change now with the new administration, but certainly over the last decade. And so it's accurate that the level of Christian hegemony, conservative Christian hegemony, has gone down in the last 100 years. And that's led to a sincere feeling of minority where they used to be the majority. And it is kind of ironic that there was a slide we didn't get to of a guy at a Trump rally holding a sign that says, "The silent majority stands with Trump." But in that sign, it's just a really interesting kind of semiotic thing. Like, okay, so it's the silent majority, so we're the majority, but we're also this kind of oppressed minority, right? We're taking back from something else. And so it's a tricky game to get into a game which I admit I sort of invited, to get into, like, who feels like the minority. because some people feel like the minority even when they're the majority, and that may now be the mainstream LGBT. And maybe it is true that an anti-gay marriage thing in some urban centers would be actually you could be persecuted. You could be wearing a shirt that just says "I support traditional marriage," and if you walk down in an urban bubble, walk down the street, people might actually shout things at you. Of course, if you wear that shirt in a different part of the country, you won't be shouted at. So I think it's a tricky thing to give too much weight to the perception of minority status.
And just to echo one thing that Jay said from the litigation, when we were arguing the contraception cases, the nonprofit one we did in the Third Circuit, Chief Judge McKee, who was the chief judge then, said, as the government was arguing, he said, the substantial burden part of this is a Rorschach test. Where you go in determines where you come out. And if I go in on the government's first step of the analysis, then the government wins. And if I go in on their first step of the analysis, then you win. And that's Jay's point about framing, right? As a litigator, how do you get around that? I think it's with facts. You have to develop your facts. You have to bring in credible witnesses and develop your facts on either side, right? If someone's saying you're just, these are just hurt feelings, bring in facts. Bring in facts. Don't let it stand as the other person saying they're just hurt feelings. Bring in the facts, because I'm sure there are facts. And so that's the job of the litigators, to go into court and develop that.
Great, thank you. I think we are out of time for today. But on behalf of Outlaw and the Christian Legal Society, thank you so much for coming. Thank you so much to Ira Carroll, Dr. Michaelson for coming to Pittsburgh. We're thrilled that you were here and we had this really important discussion. This continues. So if you're interested in getting involved with Outlaw or Christian Legal Society, please see us after the program. And any last words?
Y'all have great hotcakes here.
Great, thank you so much.